all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. We apologize for the slightly late start this morning and thank you for your patience. My name is Justice Peter Sachs. To my right is Justice Sabita Singh. Joining us on Zoom is Justice Maureen Walsh. Will be the panel for the two cases we're hearing this morning. You've been to the Appeals Court. You know 15 minutes per side. No rebuttal. We've read your briefs. We know your arguments. We know the factual record, so we encourage you to get right to the heart of your argument. With that, I will call the first case, 23P76, Commonwealth versus Philip Bunting. Mr. Benyon.
To the presiding justice, and may it please the court, the due process of law clause of the 14th Amendment prohibits a state from taking a person's life, liberty, or property without due process of law. With respect to SDP proceedings, the SJC long ago recognized that the civil-criminal distinction cannot be applied blindly to deny constitutional rights to those persons subject to one-day-to-life commitment as sexually dangerous persons, because those being committed civilly could carry more serious consequences for the individual than a criminal punishment. In 2020, the Supreme Court of the United States decided the Ramos case, which is cited in my brief. I'm sure you've read it. In that case, the Supreme Court, under the 14th Amendment due process clause, incorporated the jury unanimity to apply to states, whereas before it hadn't. And what we're arguing is that because an SDP proceeding looks more like a criminal case, because of the standard of proof, the standard of proof beyond a reasonable doubt, the fact that it can carry such serious implications for the person committed, a day to life, that what Ramos is talking about, that important fundamental right of jury unanimity, should be applied to Mr. Bunting and to all people who are committed under 123A.
What effect does your request regarding a non-unanimous verdict?
I'm sorry, what?
What effect does your request to the judge regarding how the jurors should be unanimous or majority? What effect does that have on your argument in front of us now?
What effect does?
In other words, you requested that they be instructed that they didn't have to be unanimous.
Right. So going forward, the jury should be instructed they have to be unanimous because, again, so this gets to the point that I wanted to make next. So an initial commitment proceeding has to be unanimous. All right. So under Section 14, which applies to Section 12. It has to be unanimous. It explicitly says that. It does not explicitly say that with respect to the portion of the statute that allows a person to petition for release. The SJC has addressed that before. They used the negative implication canon. In other words, they took up the idea that because the legislature hadn't specifically said it, that they meant not to say it, and therefore it would just be civil.
Well, not only did the legislature not say it, but the legislature said that the normal rules of applicable to juries in civil cases would apply.
So there's a problem here and I'll just put this out, and I agree with that. That's what the statute does say. Number one, Ramos hadn't been decided then, and Ramos creates jury unanimity in where there are serious offenses as a fundamental right. So that changed. But also, I want you to think about the idea of SDP or one of the reasons we allow civil commitment as a sexually dangerous person is to rehabilitate. One of the reasons is to allow rehabilitation of the defendant. That's why they're committed to the treatment center. It is, in my opinion, completely arbitrary and ridiculous that the statute to initially commit somebody who has never had treatment as a sexually dangerous person before. They've paid their debt to society through the criminal process, but the jury has to be unanimous, even though the person has never had any medical intervention for their specific problem. But then when they want to petition for release, specifically after 2, 4, or however many years where they have had medical services provided for them, and that's part of the part of the testimony at the trial, whether they engage in treatment or not. Mr. Bunting has. In that case, the statute makes it harder for that person to get out, even though they've had.
How does it make it harder? I mean, doesn't the requirement that there be only 5/6 of a jury affect the Commonwealth and the petitioner equally?
No, because it's not the Commonwealth who's going to spend a day to life at the treatment center.
Well, but if 5/6 of the jury concludes that the petitioner is no longer sexually dangerous, then under the 5/6 rule, the person gets released. Whereas if we required a unanimous jury, then there would be a mistrial and another trial. So why doesn't the...
No, the government, or so if the government doesn't meet their burden, then the government has not met their burden that the person is sexually dangerous and therefore can be held. The government can always try to repetition, I think, but the difficulty...
Well, when you say if the government has not met their burden, how do we tell that? If the jury cannot agree by a 5/6 margin on a verdict, whether it's in favor of the Commonwealth or in favor of the petitioner, then isn't there a mistrial and another
There is a mistrial,
trial?
but in my opinion, a mistrial is a valid outcome. A mistrial or a jury that acquits is almost the same thing. One doesn't allow the government
What
to...
about in GF? Weren't there 3 mistrials? And then there kept being more trials. So
That's what essentially occurs now, though, because the person can be can petition. But in this case, Mr. Bunting, and again, it is harder for the defendant. I want you to look at Mr. Bunting's facts. All right, one of the 2 QEs found him not sexually dangerous. Both of his experts found him not sexually dangerous, and you can say yes, but those are Mr. Bunting's experts but again, I think we've all done enough SDP cases to know that it's not that easy to get, in some cases, to get even one defense expert to come and say that the petitioner is not sexually dangerous. It's difficult. Where the jury has to be unanimous, that gives a clear indication that the government has met their burden. In this case, it's beyond a reason.
That seems to me to be assuming the conclusion. And you say in your brief, the way the law assesses whether the Commonwealth met its burden is to have a verdict rendered by a unanimous jury. What is the law you refer to when you say the law assesses whether the Commonwealth met its burden?
Well, that's the way we do it. I mean, either the government...
But under what law? It's not the statute, right?
No,
because the
I
statute
understand. But again, it's...
Or is it the Constitution?
Yeah, it is under the Constitution.
What part of the Constitution? Not the Sixth Amendment, which applies to
No, what we're talking about is the due process of law clause, where, and again, I'll go back to Ramos, the idea of a substantive procedural right is that it is so fundamental to a liberty interest that it can never be taken away through mere process, right? That's the idea. What we're looking at here is the court has said in serious offenses, the right to jury unanimity is fundamental.
In serious criminal offenses. That's
No. It doesn't say criminal. In Ramos, does not say criminal. It is a criminal case, but it leaves the door open because while it does refer to and takes up a criminal case, and it leaves the language is for a serious offense, not just serious criminal offense.
But an SDP is not being confined for having committed a serious offense. An SDP is being committed to protect the public from reoffense and to rehabilitate the SDP.
It's the mental illness is the offense, is the serious offense, whereby the legislature has allowed a person to be committed. It doesn't have to just be a criminal offense. In this case, it's the statute does require a criminal offense, one or more sexual offenses to trigger SDP. And so I think that takes care of the criminal portion. But what we're more concerned about here is the idea that I'm going to say it again. The process makes it easier for the government to commit somebody and then keep them committed, and that's the problem.
Can I interrupt for a moment, counsel? And I can appreciate many of your arguments as they relate to civil commitment proceedings and the danger and power of the data alike, okay?
Thank you.
But your reliance on Ramos is a little bit troubling in the sense that, well, we can agree or disagree, but even if we agree about the serious ramifications and criminal-like sentencing of civil commitments, they're civil in nature, right? So Ramos was a criminal case and it was a Sixth Amendment. And this isn't. And I mean, your argument would be a great one to the legislature that this is unconstitutional, the civil commitment proceedings, but, you know, so far that hasn't been a successful argument. And that if the Commonwealth wants to commit somebody, they have to do it under a criminal statute with a criminal standard and unanimity. So I'm having a hard time making the jump that Ramos opens the door, since it's really a different context, at least in the legal analysis.
So again, I'll say this. What Ramos says is that to have a unanimous jury, and I'll agree with you, Ramos is a criminal case, but to have a unanimous jury is a fundamental right. Now, we can argue whether, and that's what we're doing, whether Ramos applies to just a criminal case and no other. But again, look at what Ramos is saying. It's saying that under the Due Process of Law Clause, a unanimous jury where there is a serious offense, and I think if you read the case, it's talking about the idea of serious, the consequences that come from a criminal case. And if what we're looking at here is an SDP case more like a civil case or a criminal case? And in certain proceedings, it's civil. That's true. It is a civil commitment. It's to a hospital or a treatment center. But, you know, that treatment center has 20-foot razor wire fences and bars on the windows, and it's a commitment to a day to life. So in that sense, it looks an awful lot like a criminal case, and that's why the SJC has said that you can't just look at the criminal-civil distinction and apply them when it comes to constitutional rights. There is a constitutional right to jury unanimity, where that, and I understand what we're talking about, but I am looking at this case as a defense attorney who has a client who's done 15 years in the treatment center after he's paid his debt to society through the criminal process. And the way it's set up now, it does make it much more difficult for him to leave. Unless it's two QEs who say no, or who say not SDP, he's more than likely going to stay in there. Because a jury is the ultimate arbiter. And that's, I think, why I think we as Americans put so much emphasis on the jury of our peers to kind of decide our fate. The SJC's already made some wonderful case law on this, and again, it's criminal, but the SJC has highlighted the importance of jury unanimity as it relates to getting the case right. So on page 33 of my brief, it's in footnote 4. When we get a number of people together from the community and we present the evidence to them, the idea is that they're combined, just like an appeals court panel is made up of more than one head, more eyes to look at the problem. The same thing with the jury. You take 12 members, and if they're unanimous, then you can have confidence that the government has met their burden when they're going to take away a citizen's life in a criminal case or a civil commitment.
Can I ask you again? There was no request for a unanimous verdict, correct?
There was not.
Okay. And so are you entitled to make this argument at this point?
Because this is a constitutional right, and you can't waive a constitutional right unless it is explicit, certainly not a fundamental right, which is what Ramos deems the right to be, then no court has looked at this. You haven't looked at this before. And if you're going to say that...
Well, the SJC looked at it in Sheridan, and you're asking us to reconsider under Ramos, the U.S. Supreme Court case.
Yes, that's what I'm trying to do.
Ramos was decided in 2020,
Yes,
and this case was tried in 2023?
yes.
I wanted to ask you, you argue that there's no rational basis for the distinction between Section 9 and Section 14. The SJC and GF said the rational basis is that a petition under Section 9 has at least had the opportunity for at least a year of treatment, whereas in a Section 14 initial commitment, that's not the case. And that provides the rational basis for permitting a 5/6 jury in Section 9 cases.
Again, I thought I addressed that. It doesn't make a lot of sense that you can initially commit somebody with a full jury where they haven't had any treatment, medical treatment, and then once they do have medical treatment, then you allow fewer jurors. The law then allows the...
Okay. Well, are we free to disagree with what the SJC said in GF?
If you find, and I see my time is up, but if you find that Ramos does create a constitutional right to a unanimous jury, and if you believe that an SDP proceeding looks more like a criminal case, then yes, you can.
Okay. Thank you. Thank you for your argument. Ms. Murray.
Good morning, and may it please the Court. Mary Murray for the Commonwealth. The federal Constitution does not provide for proof beyond a reasonable doubt in a civil case. Addington against Texas, 1978. Comstock, 2008. No right, it's a clear and convincing evidence standard to begin with under the federal Constitution. You have no federal constitutional right or under the Massachusetts Declaration of Rights to a jury trial at all in civil proceedings. The SJC has already decided that. In Barboza specifically, in the early 1980s, the SJC said, we decline to extend the Sixth Amendment right to a jury to civil SDP proceedings. That is at 387 Mass at 112. The next page, 113, the court said, and we also find you have no Article 12 right under the Massachusetts Declaration, which applies only to criminal cases. With respect to the statutory right to a jury trial, the very day, several years later, the SJC considered the Gagnon case, where there was an argument you have a constitutional right in a discharge trial under Chapter 123A, Section 9. The SJC issued Gagnon in January of 1994 and said, no, you don't. The very next day, the legislature amended the statute to provide for a statutory right to the jury trial as part of a larger overhaul of Chapter 123A. And in the statute, the SJC said, the legislature said, if a jury is demanded by either party, it shall proceed according to the civil rules. What does that mean? In Sheridan in 1996, the SJC said, 5/6 jury, unanimity is not required, it's not constitutionally required. If the petitioner most respectfully seeks a change in the quantum of jurors necessary to reach a verdict in an SDP Section 9 case, his remedy is either with the legislature or most respectfully the SJC, because as this court has said time and time and time again, as recently as January 19th, in a case that Justice Sachs sat on, Commonwealth versus Steve S., and another case that Justice Walsh sat on, which was a Rule 23.0 decision, Delano Pierre, that this court does not have the power to disregard, overrule, refuse to follow, or amend the holding of the Supreme Judicial Court.
So can you explain what the court meant in GF when it said the rational basis for the 5/6 rule in under Section 9 versus the unanimity requirement of Section 14 is that a Section 9 petitioner has had an opportunity for at least a year of treatment? How does that provide a rational basis for the different requirements?
Because they're not similarly situated individuals. Somebody who's been, who's at the initial commitment stage has not had a right to that treatment, and somebody who has been committed to the treatment center is committed for care, custody, treatment, and rehabilitation. And of course, part of that is offering a treatment program that is suitable according to the reasonable professional judgment of the people charged with offering it. And the SJC has specifically said repeatedly that a rational basis standard of inquiry applies to equal protection challenges brought by sexually dangerous persons in Dutiel and again reiterated in GF.
So I understand that there's a factual distinction between Section 9 petitioners and Section 14 defendants. But how does that rationally relate to the different requirements for jury unanimity or lack of unanimity? I mean, you could say that if people have red hair, then the jury has to be unanimous. If they have black hair, then a 5-6 jury is sufficient. That's a factual distinction, but how does it rationally connect to?
It's also a legal, that would not be a rational basis. We'll just agree to that. Blue shirts, red shirts, pink hair, no hair, no, that's not rational, and we would agree to that. However, the court looked at their circumstances from a legal standpoint, which is somebody who has been civilly committed has a right to and an opportunity to participate in that treatment. And the people who are at the initial commitment stage do not have that right and have not had that opportunity for treatment as a sexually dangerous person. And that was what the SJC found guiding. And in that case...
Why? How does it make sense that someone who's had an opportunity for treatment faces a jury that needn't be unanimous? Or that needn't be unanimous in order to find the person not sexually dangerous?
That's right. It's more advantageous to petitioners to have a non-unanimous jury in the Commonwealth.
Is it more advantageous, or does it affect each side equally?
Oh, I think it affects each side, but I think, in my opinion, the reason why we don't see very many requests for unanimous juries is the experience of the petitioners that they think it's more advantageous to not have a unanimous jury. But I don't want to go outside the record here too far. But because the treatment, yes, to get back to your question, the treatment that's offered is intended, if the person participates and profits, to address the mental condition and the other risk factors that renders the person sexually dangerous. So that treatment opportunity, again, if participated, profiting from addressing the recommended areas, that puts you in a different position than you were at the stage when you were coming through the door.
Different how?
Because one of the questions is whether the person is likely to reoffend sexually.
If you've had an opportunity for treatment, then perhaps you're less dangerous.
That's right.
And therefore, why shouldn't the Commonwealth have to do more to keep you confined?
Well, the Commonwealth still has to prove the case beyond a reasonable doubt.
Yes, but why shouldn't it have to prove it to a unanimous jury rather than merely 5-6?
Because the SJC has said there's no requirement of unanimity to prove its case beyond a reasonable doubt.
Okay.
Those are separate constructs.
Legal requirements aside, what's the common sense explanation of why the non-unanimous jury is acceptable or better or makes more sense under Section 9 than under Section 14? What does the opportunity for treatment have to do with whether the jury should be unanimous or not?
I'm trying to follow your question, so give me a moment to parse through it. Okay. The opportunity for treatment is an opportunity to address the mental condition, to learn to control whatever the behavior or whatever the condition was that drove the behavior, led you to have uncontrolled or uncontrollable sexual impulses in the community, to address the risk factors. For example,
yes, it gives you that opportunity.
Right. So with that, what the SJC was looking at was the legislature's distinction. The legislature, this is all a matter of statute. The legislature said unanimous in Section 14 trials, civil practice in Section 9 trials. And as we know, the SJC in Sheridan said it's not required to be unanimous to meet the burden of proof beyond a reasonable doubt. In GF, where the trial judge, after the 3 mistrials, was inclined to give an asymmetrical instruction for an asymmetrical verdict, unanimous to find sexually dangerous and not unanimous 5-6 to find not sexually dangerous, the court said, one, we don't have asymmetrical verdicts, and two, the difference is the rational basis for the distinction that the legislature could have found is that difference in treatment opportunity where the person can address the risk factors and the conditions that drove the prior uncontrolled or uncontrollable sexual misconduct. So that was the basis. And
They said it, it's the law, we have to follow it, but I'm not understanding it.
okay. In any event, Ramos doesn't take us anywhere. It's applying the Sixth Amendment, which by its express terms only applies to criminal cases, which the SJC has already declined to extend to civil SDP proceedings. And in short, Mr. Bunting is asking for relief under the wrong statute from a court that has already told us many times it's bound to follow the SJC's holdings. And so this would have to be addressed either with the legislature or with the Supreme Judicial Court. For those reasons, for all of the reasons stated in the Commonwealth's brief, and based on the strength of the Commonwealth's case below, the Commonwealth urges the court to affirm the judgment. And unless there's any other questions from the panel, the Commonwealth will rest on its brief.
Seeing none, thank you for your argument. Thank you both. And our second case will be 23P 703, Commonwealth versus Andres Luis Ramos.
Thank you. Please the court, Joseph Asone for Mr. Ramos. The crux of my first argument, Your Honors, is that the police officer's repeated statement that when people are on a run selling drugs is tantamount to commenting on the ultimate issue, which is in the jury's province, which is guilt or innocence. Because
Where did you object to or move to strike any part of that answer?
The trial attorney objected to the admission of the opinion as a whole, but not directly.
Right, but is that sufficient to preserve the issue?
I think it is, because it goes to the heart of the objection, which is you're testifying to something that is in the jury's bailiwick. It's not in yours. You're an expert. You can say that a certain kind of behavior is consistent with distributing or the intent to distribute, but you can't say that the person is guilty of the offense. When you say that when a person is out selling drugs and the hypothetical that's given to you is identical to the actual state of the facts, which was before the jury in terms of the conduct of the defendant, and you say that's the conduct, the hypothetical conduct is the same, this person engaging in the hypothetical conduct is selling drugs.
Right.
Therefore, he is selling drugs.
So there was a motion in limine, an extensive argument, and Judge Deakin essentially expressed some personal reservations about
He did.
the law that allows this sort of hypothetical question.
Yes.
But he said, I'm bound by the decisions that allow it, so I need to allow it. In your view, did the objectionable parts of the answer here go beyond what Judge Deakin felt he was constrained to permit?
Well, I think it did, because...
All right, so that's where I'm asking, where was the objection to that? Because a ruling on a motion in limine will preserve an objection if the objection is at trial is precisely the same as what was at issue in the motion in limine. But what you're saying is that the answer here went beyond what Judge Deakin permitted, yet that wasn't called to his attention with a request to strike the offending parts of the testimony, the parts that said, when a person is on a run selling fentanyl, this is what they do.
Well, it was a general objection to the entire opinion, and I believe the reason at trial that there was an objection is because the motion in limine pretrial the defense knew what was going to be said and that something of this sort was going to be said. Because I think there's an agreement that an expert can say that certain kinds of conduct or behavior are consistent with selling drugs, but you can't go beyond that and say that this person is guilty. And so because
That's
there
not
was...
what happened here, right?
I'm sorry?
But that's not what happened here. The testimony wasn't, this person is guilty.
Well, when you say that a person is out selling drugs and the person is before the court charged with selling drugs, illegal drugs, and if you're saying he's selling drugs, then you're saying the Commonwealth has met all of the elements, has proved all the elements of the offense. I mean,
That's
it's
what's
kind of a shorthand way of saying it when you say selling drugs. I mean, it didn't say each one of the underlying elements, which constitutes possession with intent or distribution. But you say he's selling drugs. That's what the jury is there to determine. Did he have possession of this just for his own personal use, or was he selling it or distributing it? And when you say he's out selling drugs,
All right, so
I don't think the jury needs much more than to hear that.
so your argument is not that the hypothetical precisely matched the facts of the case. Your argument goes more to how he couched this in terms of the hypothetical person selling drugs?
Right. It's the selling drugs portion, okay, which was not in, the motion in limine doesn't say that the officer is going to say selling drugs, because I don't think the judge would have put his stamp of approval on that. But at trial, that's what the police officer said, and there was an objection. But it's difficult from the record to see precisely what portion of the officer's opinion was being objected to. It seems that, again, if he left out that selling drugs portion, then I don't think I'd have much of an argument, quite frankly. That's what put it over the top. You have a hypothetical that's pretty much identical to the facts of the case, and then you take that and put he's selling drugs on top of it. That's the selling drugs part is what puts it over the top, the straw that breaks the camel's back, so to speak.
So assuming that the objection to this was not preserved, we would review for substantial risk of miscarriage of justice.
Right, substantial risk.
Right. So how would this testimony create a substantial risk of miscarriage of justice, given the quantity of fentanyl involved and the absence of any paraphernalia for using it?
Well, again, I would say the case for distribution is not as strong as, say, the case was in Woods, which is a case that the court referred to. In Woods, the saving grace in that case is that the police officers were recipient witnesses. They made all the observations. So it wasn't really them giving an expert opinion so much as it was, relaying what their actual observations were. Here you have a police officer, a trooper, who didn't see what was going on, never saw anybody distributing anything. The whole distribution aspect of the case was based on the fact that there was a certain quantity of drugs, and there was it coupled with the absence of the accoutrements of personal use. There was no needles, there was no spoons, whatever. There was no items that are commonly used when you ingest drugs. So therefore, it's not possession, it's distribution.
Counsel, can I ask a couple of questions? One, I want to make sure I'm clear. Do you agree that the standard of review is substantial risk of miscarriage of justice?
Well, I think because the objection was what I would term a global objection to everything that the police officer was saying, I argued in my brief that it was, prejudicial error standard, a much lower standard. But, to answer Justice Sachs' question, if we elevate this to a substantial risk of a miscarriage of justice, my point is you have a weak case for distribution in that there was no observations by anybody of
Okay, but look, I just want to, let me interrupt. I just want to make sure I'm hearing two different things. You are not agreeing then that we review this under substantial risk of miscarriage of justice.
Correct. I'm not. I do not agree that that would be the standard. What
Okay.
I'm saying is, however, if this court were to say, disagree with me and say, no, we think we do have to use the elevated standard, I'm saying that it would even meet that because I don't believe the Commonwealth's case was strong enough to overcome
Okay.
even a substantial risk hurdle.
Okay. And secondly, I want to make sure I understand your argument.
Yes.
It's a little bit different than in your papers. You're conceding that if it was just the hypothetical alone, that regardless of the burden or the standard of review, that the hypothetical in and of itself isn't the issue, or isn't.
Right.
It's the combination of the hypothetical
Exact-
with consistent when people make a run that are involved in the distribution of fentanyl.
Correct. It's yeah, because now the jury says, well, he says if this hypothetical individual does exactly the same thing as the defendant, has the same amount of drugs, doesn't have any of the accoutrements of personal use, and he's making a run, and this guy's making a run to sell drugs, therefore, it must follow that this defendant was making a run to sell drugs, and therefore he is guilty.
Because the hypothetical, I mean, it seems as if in Commonwealth versus Dancy, the hypothetical was very similar, right?
To what actually was, yes,
right.
to what actually
Right.
the defendant,
So what differentiates Dancy in this case is that added statement with the general objection that you think makes a difference.
yes, he's selling drugs, and he didn't just say it once, he said it a number of times. And not to get into the second argument prematurely here, but I mean, this doesn't exist in a vacuum. When you have the officer also saying, this stuff is 200 times more powerful than heroin, and, there was a time when even, drug dealers, as despicable as they are, wouldn't sell this stuff because it was so dangerous. And then you're saying, okay, well, this guy's a pretty bad guy. And then you say, well, they're selling drugs. So it just kind of, adds to the mix for the jury.
But the potency
Yeah,
was
he
relevant.
was selling drugs.
But the potency was relevant to the issue, was relevant to the issue, wasn't it?
Well, that's what the Commonwealth would argue. I would say, it isn't. I mean, their argument is it's so potent that you don't need to have, if it's personal use, you don't need to have this amount of drugs. Well, if somebody had a gallon of alcohol, yeah, if you drink a whole gallon of alcohol all at once, it's going to kill you. But if you drink a little bit at a time, it's personal use. You're not distributing the alcohol. And the same analogy can hold with drugs. Yes, he had 70 grams, but he's not going to ingest the whole 70 at once, because if he did, he would be dead 100 times over.
But those are all arguments that both sides can make in explaining what the reasonable inferences should be. But wasn't the expert entitled to explain the different potency? Because the jurors wouldn't necessarily know that and would not have an understanding of small amounts being consistent with distribution.
If you're engaged in the illegal commerce of selling drugs, what difference does it make how potent the drug is that you're selling? I think it's common knowledge to everyone that this stuff is extremely powerful, and if you use... So why would the jury need to know that? Whether it's possession with intent to distribute cocaine, which, arguably will not kill you unless you really, really use a lot of it, as opposed to this. What the mindset of I'm distributing something, okay, has nothing to do with, the makeup of the thing I'm distributing, the potency of it. It's there, and I'm not saying that the Commonwealth did this intentionally, but it inflames the passions of the jury. That you're an individual who's selling something that's so potent that, you get the dosage off just by a smidgen and you die. And in fact, people as despicable as you who sell drugs at one time had some conscience, and they wouldn't sell fentanyl because it was so powerful and so dangerous. the risk factor was, very, very high. So that inflames a jury. I mean, there's.
And yet there were no objections?
I think there was an objection. Well, there was an objection to the, again, a question was asked, there was a response and an objection, but it was the testimony wasn't just answering one specific question. If you look at the way the expert testified, he kind of rambled on and kind of added stuff in that really wasn't, answering specifically, the question that was put to him.
So wasn't there an obligation to object at that point?
Well, there was an objection, but I don't, you can't say, okay, he objected to this particular thing. He would say stuff, and then they would object, and the judge would. So it's the way he testified and the way he kind of rambled on. It's kind of difficult reading a transcript to say, oh, he was objecting specifically to this portion of what he said, but not really to this portion. It's just an overall objection. So I think it's kind of disingenuous for the Commonwealth to say, well, he didn't quite object to this particular portion, therefore, we have to jack it up to substantial risk of a miscarriage of justice because you didn't properly object.
But isn't that the lawyer's job? You hear something that inflames the passions of the jury, isn't it your obligation to object and state the specific ground?
Well, yes, and I think he objected. I don't know if he specifically said that particular, the 200 times. I mean, what I think he objected to, trial counsel, was this whole history of fentanyl, that it's, the history of fentanyl is that it's an extremely potent drug, and, historically people, were selling it, and then they decided, geez, we don't want to sell this because it's, it's just killing too many people. I mean, what do you need all that for? The history of fentanyl, why is that? Well, how does that go to the ultimate question for the jury is, was this person selling drugs or was he not selling drugs, or distributing drugs or not distributing drugs? It's, whether it's a drug or you're distributing lollipops, what's the difference? You have a product, do you have the mens rea to distribute this, or you don't? And how powerful it is, in my view, is completely irrelevant, and I see I have 27 seconds left. And
no, that's counting your overtime here. So.
I'm overtime.
If there are no further questions, we'll hear from the Commonwealth.
Okay, thank you very much.
No worries.
Maybe you could use it.
Thank you, Your Honors. And may it please the Court, Patrick Cespedes from Middlesex on behalf of the Commonwealth. Under directly analogous circumstances, the SJC and this Court have repeatedly held that drug distribution experts may testify to hypotheticals grounded in facts and evidence. Sergeant Troy did so here, responding with the proper consistent with language. So there was no error and certainly no substantial miscarriage of justice. Just to give one example from the SJC, Commonwealth v. Little, 453 Mass 766, the expert was asked about a hypothetical person who's arrested with 15 individually packaged bags of marijuana, $254 in loose currency, and no smoking paraphernalia. The expert testified this was more consistent with an intent to distribute than personal use. The SJC held that the hypothetical and the response were both proper, and it's the same thing here. Here we had 70 grams of fentanyl packaged individually, $335 in loose currency, and no personal use paraphernalia. The hypotheticals are virtually indistinguishable. So
I think the particular objection that is being raised, at least on appeal, is to testimony at pages 73, 74 of volume 3 of the transcript, where Sergeant Troy says that the scenario that's been described is consistent with when people make a run that are involved in the distribution of fentanyl.
Right.
When they're selling, going out, making a run, and selling drugs. It's those particular phrases that are being objected to. Are those kinds of things permitted under any case law you can cite? Absolutely. Not only is that okay, it's actually encouraged. I would point this court's attention to Dancy, 75 Mass Appeals Court 175. Well, I'm not asking about a hypothetical that exactly mirrors the evidence about the defendant's conduct. What I'm asking about is phrases like, when people are selling drugs, this is what they do.
So-
rather than if, the facts of your hypothetical would make me opine that the person was selling rather than using.
Right. So in Dancy, the court says one way that we should evaluate an expert testimony is whether or not it is explanatory or conclusory. In this case, the prosecution didn't ask, give the hypothetical, receive a one-word answer, and say no further questions. The prosecution followed up with question, what's the significance of this? Why do you think this? And the expert responded by saying, here's the significance of the quantities, here's the significance of the packaging, here's the significance of the loose currency, and no smoking, no personal use paraphernalia, and all of these things actually lend support to the expert's testimony that this isn't conclusory. It's part of a broader explanation of what it means to distribute fentanyl.
Counsel, can you define in what you believe the term hypothetical means?
Sure. In this court's case law, as well as the SJC, the hypothetical is taking certain facts admitted in evidence and asking the expert, is this consistent with intent to distribute or personal use? Now, there are, sort of guardrails in place, as this court as the SJC has recognized in other cases. I'll point this court's attention to Almeal, whose reasoning was adopted by the SJC on further appellate review. There's a meaningful difference between a non-percipient expert witness, like Sergeant Troy, who states that these facts admitted into evidence, which the judge has already determined were relevant, is consistent with an intent to distribute, versus a percipient witness, say, the arresting officer, who gives a conclusory answer that, based on his observations, his personal observations of the defendant, and putting on the other hat, in his expert opinion, the defendant did in fact intend to distribute. So here we had as close to a model as you can get when it comes to posing this hypothetical, using certain facts and evidence. Now, the defendant could follow up in cross-examination and say, hey, is this particular fact relevant? Is this one relevant? So those are appropriate topics for cross-examination.
Would you agree? Would you agree with me, though, Commonwealth, that it would not be permissible for the Commonwealth to have that same expert be asked, do you think that the defendant's guilty of possession with intent to distribute? You'd agree that that would not be permissible, correct?
Correct.
So when a hypothetical is exactly, and I mean exactly, all of the facts admitted into evidence. I'm having a hard time couching that as hypothetical. It's basically saying, hey, based upon all the facts of this, what do you think? And he says, yeah, that's consistent with drug distribution.
So in this case...
Isn't he testifying as to the ultimate issue of guilt in an element that the Commonwealth has to prove that is in the jury's province?
No, Your Honor. In this case, the expert testimony was touching on an ultimate issue of the case in an appropriate manner rather than directly commenting on the defendant's guilt. In so doing, in terms of touching on the ultimate issue, you can, if it is helpful to the jury, and narcotics distribution, as this court has recognized, is not something that's within the ken of the jurors. So that's one aspect. It's helpful to the juror. And is it within the field of expertise of the expert? And here it undoubtedly was. And so in this case, it is an appropriate testimony that touches on the ultimate issue but does not directly comment. Moving to the second issue regarding the question about effects, potency, Your Honor's asked, was there any objection? The only objection was to the effects of fentanyl being similar, if not identical, to heroin. That was on transcript volume 3, page 57. So anything regarding potency or typical dosages of fentanyl were not objected to. So the standard of review would be substantial error, substantial risk. In this case, potency, as Justice Singh alluded to, was highly relevant to this case. It goes to show that even a small amount of fentanyl, especially when compared with something like heroin, which has identical effects, even a small amount can be consistent with an intent to distribute. So in that sense, highly relevant. this court has no further questions, Commonwealth will rest on its brief.
Seeing none, thank
you,
you
Your
both for your arguments. That concludes our sitting today. I'd like to thank our court officers and our law clerks and our court clerk's office for their assistance. And with that, we'll be in recess.
Court all rise, please.